Let's record. Okay, hi to the folks at home. This is the contract B for week 2. And for week 2, we are looking at the wonderful world of misrepresentation. Now, is anyone at this point confused with the whole notion of misrepresentation? How are you going with your readings for misrepresentation? I know that misrepresentation readings are like massive, and I just want to make sure that you're all good with this. How are you going with it all? Hello?
I'm getting there.
Getting through it, struggling. It's a huge...
It's something that I think we will need to reread several times.
Yes.
You can just read once. There's so much information, a lot of little note taking.
Yes, and I think that if we keep the common law of misrepresentation very separate in our minds to Tim's a visual guy. If we keep the common law very separate in our minds to the statutory side of things, I think that will really help. And, I do say, I think online, we'll come back and revisit this later on, because the statutory side of things is the side that you really need to be familiar with in terms of your professional practice. Yeah, Tim, there is a lot of reading, but you need to everyone needs to wrap their collective heads around the fact that this is a 6 credit point unit. So that means that technically we are allocated 12.5 hours per week for readings and for tutorial work. You will, in your law degree, be required to read around 100 pages per unit per week. So that's just life as a law student, unfortunately. I would strongly counsel you against just going off the movies, the videos. But what I would do if you want to cut down your reading, this is just my personal suggestion, #hot tip. Personally, I would do the videos and then I'd skip straight to the text, because I think the study guide is really just double handling. And I would use the study guides as a basis to build your own notes that you can then print off and take into the exam. That's what I would be doing. I wouldn't even be worrying about using the study guide as part of your actual reading, because I think you get enough of a bird's eye overview of things with the videos. And then you've got enough of a map in your mind to be able to confidently, confront the actual text and the casebook. I think that's more than sufficient. Can I tell you, whenever yes, Shona, the study guide is a good summary, but never, ever, ever rely on the study guide for anything. Don't rely on it for assignments, and certainly do not rely on it for exams. And this is why. The study guide, being a summary, is only going to tell you the bare bones, and it won't give you enough detail of the case law. And as I've said to you last week, contract law really is all about the case law. And your IRACs, your problem answers, will stand or fall on the basis of your knowledge of the case law. If you don't have a really detailed knowledge of the principles, and that you can only get from reading the text, and a really detailed knowledge of the case law, and that you can only get from reading the case book, you are not going to do well in your assessable work. And I think I said on Facebook, in any event, you know, you wouldn't want to be relying on a lawyer that graduated from uni having just read study guides. I think everyone agrees that the issue of one's professional indemnity insurance would crop up regularly. 51%. I'm not sure what the query is about. 51%. Did you want to explain that, Keith? Did you have a query?
No query, just a cynical comment.
Oh, I'm all for cynics. That's okay.
Grade A.
So that's just my little personal way I would try and cut things down. Now, if you don't get through all of the statutory readings on statutory misleading and deceptive conduct, that's okay, because as I said, we'll probably revisit it later on in the term. But there is a series of questions that I have posted up on Moodle for people that are looking for a revision. Someone's just said the study guide's good for revision questions. I have posted up on Moodle some revision questions on misleading or deceptive conduct for you, so that once you've finished your misleading or deceptive conduct material, you can go back and test yourself. And as I said, normally in about week 10, I usually go back and revisit all of that stuff. Let me just close this all and let me just check what I've done this term. I have changed some things around. I'll just have a quick look here and see what I've done for you. No, it's still in week 10. So we come back to this and we do review things again in week 10. Now, at that point in term, what we are looking at is the remedies for misleading or deceptive conduct, more so than the actual action for misleading or deceptive conduct itself. So if you can get across the readings now on the actual action itself, that would be super useful, because then all you really need to do is add to that knowledge in week 10, okay, in terms of remedies and what you get for a successful action in misleading or deceptive conduct. Now, for those that have other cases mentioned in the study guide, the most important to that week's topic, Shoda, I think someone asked this to me on Facebook. No, I don't go from the study guide at all. I don't proceed at all from the study guide. Do not be guided by the study guide in any way, shape or form. The examinable metes and bounds of this unit come from the text and the casebook. Okay, so already for those people that have looked at the first assessment online, it's up on Moodle, you will see I've given you instruction on what you need to read. So you need to read the text chapter on duress and the text chapter on unconscionable conduct. And you also need to read the two cases that I have told you to read in full online. So you'll need to read the ACCC and CG Barbatus Holdings case. And you'll also need to read the lovely case of Barton and Armstrong. The cases mentioned in the study guide, most important to that week's topic. Oh, sorry. Okay. Yes, thumbs up. Sorry. Yes. So no, they're not. They're no guide whatsoever. I personally am in the process of rewriting all of the study guides, because I don't think that they are as useful as they could be. So go straight from the text and the casebook and my videos, and you'll be sweet. As I said, if you want to use the study guides as the Word document that you build your own personal set of notes from, I don't mind that. But anything else, and please don't cite the study guides in your assignments. Just telling you. And please don't cite the text in your assignments, okay? So when you're writing your assignments, you need to bear in mind, I don't know if this was emphasised to you in Contract A, but you write your assignment as though you're basically writing a judicial opinion. And that is, you never refer to a secondary source, which would be casebook, scholarly written articles, web articles, anything else. you really have to restrict yourself to primary resources, which are cases and legislation. Okay. Did Susan mention that to you for contract A? Yeah. Okay. All right. So that's the way that you do these things, because it's assumed that law students, when you're discussing cases in an assessment, that you will have read the cases involved, or at least read the case extracts from the case book. Wherever I say you need to read a case, obviously in full, and for this first assignment, there's 2 that you need to read in full, then you need to have read those in full. So out of curiosity, is there ever a time that we do need to look at secondary sources? Yes, there is, and that is called your legal research subject for years 2 or 3, wherever you decide to do it. So where you are writing a scholarly article, a scholarly research article, or an essay, you may feel free to refer to secondary resources. Yes, but where you are providing advice to a client, then you need to be going off of primary resources, because that's your most reliable source. You get it from the horse's mouth, so to speak, rather than from someone who's heard the horse's mouth, if that's what you would call a secondary source. Okay, so that's the go with all of that. Now, in terms of the IRAC for this evening, why don't I share my screen and we can look at the, we don't want to, let me just save that there. I will shut that. Okay. Oh, look at all the things there. Go away. All right, now let's have a little look at the week 2. This stuff, for those that have already, for those that have not watched this is all on the common law of misrepresentation, okay? So tonight's tutorial will basically focus on the common law of misrepresentation rather than the statutory form. Okay, so I'll start it.
Rocco, please come in. How's business? You still make the best pasta in town, you know.
Hey, thanks a lot. You should come back into the restaurant soon. I'll have the chef make you something special.
You know, I'd really like that. But in any event, welcome to my shop. What can I help you with?
It's a bit embarrassing. I've been pretty foolish, I think.
You know, everything you tell me here is confidential.
Okay, you remember Maria?
The waitress in the restaurant. She was lovely.
Yeah, I thought so too. In fact, once she began working for me, I started to feel pretty strongly about Maria. I guess I started pursuing her. You know, romantically.
I understand. How did that go?
Not too well. She wasn't real interested at first, and I wasn't sure how hard to push. You know, being her boss at all. I didn't want to have to come see you about a sexual harassment claim.
That's very wise.
Anyways, eventually she seemed to come round. We went on a few dates, had a few laughs, maybe a couple of overnight stays. You get the picture?
Sure.
As things progressed, I was like a teenager all over again. Daydreaming about her, distracted at work, trying to make little romantic gestures all the time. It was nice. She wasn't really doing the same in return, but some girls are like that. I thought things were going nicely.
Were they?
Well, there was this big incident. Maria came to see me and said she was in trouble. She used to date this slime called Ed. Ed was involved with drugs. And now the drug pushers were after Maria for 30 grand, which they said Ed had borrowed. If they didn't get it, they threatened to burn Maria's house down. Obviously, Maria didn't have that sort of money. She came to me for advice.
What advice did you give her?
Well, I told her I would lend her the 30 grand and that she should pay it to the men and then immediately afterwards go to the police.
That's extraordinarily generous.
Yeah, but I thought I was in love. And there was something kind of cool about coming to the rescue of a damsel in distress. You know? Kind of like a gentleman.
Did you give her the money?
Loaned it to her. Yeah.
Do you think she will see it as a loan?
Oh, yeah. We signed a piece of paper saying so. I didn't really want to. I didn't really expect to ever see the money again. But she insisted that she wouldn't take charity and made me sign.
Did she take the loan money and pay the drug dealers?
That's where the whole story gets a bit crazy. Next thing I know, you see, she's driving around in a new car. She never brings it to work, but I've seen her around town in it. And I hear one of the other waitresses saying that she's just bought a new laptop computer and a new TV set and got pay TV connected. I'm not sure there were any drug dealers at all. I asked Maria about this, and she broke off our relationship saying I didn't trust her. Damn right I don't trust her now.
That's probably a fair call. What do you want to do?
What do you think? I want my money back. Can you help me?
I'll certainly do my best.
Okay. Let's get out of the screen mode here. There we go. Okay. So, I'll just get us all back here. Stop sharing. So, why are we dealing with the common law of misrepresentation? Who has an easy answer for me? What immediately says to you we can't be dealing with statutory misleading or deceptive conduct?
It's not a corporation that's involved.
Yes! Yes, exactly. Oh, Diane, you can't hear me? Are you having trouble with sound? Is anyone else having... Oh, okay. Well, I'll try and speak up. How's that? Is that any better? So, the very simple way to filter out the statutory mechanism is that if you are dealing with what we call natural persons, it will generally speaking be the common law of misrepresentation, except if we are not looking at the Commonwealth Competition and Consumer Act, but we are looking at what? Do we know? Because there are acts that might help us out, just not the Commonwealth one. Yes, thank you, Tyler. The state or territory versions. So all of the states and territories enacted mirroring legislation to the Competition and Consumer Act. And the beautiful thing with state and territory legislation is that it's not limited by the same kinds of constitutional fetters that surround the Commonwealth Parliament. So the states and territories can legislate against misleading or deceptive conduct in relation to anyone, natural persons, companies, whatever, but the Commonwealth can only legislate in relation to companies. Okay? So whenever you're looking at a situation like this, going through the back of your mind in an initial sense will be, can I use the statutory form of misleading or deceptive conduct? If I can, I would like to. But if it's a natural person, I'm only going to be able to be dealing with the state or territory legislation. And that may not help you out, for example, if you were dealing with parties that were in different states. Okay? So that's a simple way of trying to filter out what's applicable here. Now, if we look at, here's something that I prepared earlier. No, I won't show you my cheat sheet notes. I'll just ask you some questions. In terms of the common law, the categories of misrepresentation, what are the categories that we have? I might share. I'll start just a blank doc. Okay, categories.
Did I?
Did someone yell out something? There's 3 categories.
Innocent,
Negligent, fraudulent.
negligent, and fraudulent.
Yay, that's it. Someone's saying something in the chat here. People are jumping in. Yay, thank you for that, Nicole. Innocent, negligent, fraudulent. Okay. And what are your main remedies for each? Well, there's one remedy that's common to all 3.
Rescission or damages.
Yay! And which one can't you get damages for?
Innocent.
Yes. Yes. Well done. Innocent, no damages. That's it. So, innocent. Is this a case, do you think this would be a case of innocent misrepresentation? What was the story here? We had Rocco and we had Maria.
Fraudulent?
Yeah, we think so, don't we? What did he say? What was the general, let's get down what the facts were.
He said he didn't want to sign, but he did sign the contract. That's where I get stuck.
Was it on a napkin?
Oh, I did not hear that.
It was something, but they ended up writing something. He said that he didn't want to, you're right, he said that he didn't want to enter into
Sign anything,
contract.
but she forced him. Like she said he wanted to.
Yeah, Tim has said she said she was involved in illegal activity with a third party. That was her ex-boyfriend Ed, wasn't it? What did she say was going on there?
She owed him. They were going to house.
Yes, Tyler, they wanted money from her. Tim, there were death threats. Oh, I think they might have said something like they were going to burn her house down or something, didn't they?
Yeah.
Because she had to pay off some drug dealers. They were going to burn house down. Okay. All right.
Can I just throw a point out there on that?
Yeah.
With the signing of the document, he's the one handing over the cash and saying, well, he didn't really want to sign anything. He was happy to give it to her. And she's the one saying, well, no, we should put this in writing. I want to sign something. So if her story is true, then maybe it could turn out to be innocent as well. I don't know.
Possibly. She suggested the contract in the first place. Can anyone think of a counter argument to that? If I have an intent to defraud someone, Nick on TV. Can you expand on that, Keith?
The subsequent actions would seem to indicate that she did have an intention, if certainly not at the time to defraud, then maybe just being opportunistic.
Well, it was either opportunistic or you could be more cynical and say, well, perhaps often these people are confidence people, confidence tricksters. And so in order to make them seem more genuine, they will often do stuff like this. They will often suggest, oh, look, let's put everything into a contract. Sure, no problem. Because they intend to abscond before anything's actually happened. So the counter argument to that might be, was she just trying to win his confidence? Okay. What else? What happened? He gave her, was it 30,000? So $30,000?
Yep.
Yeah. Okay. And then what happened? Then she spent the money on expensive stuff, Tyler's saying, tried to hide that from him. Rocco fell madly in love with her along the way. I feel sorry for Rocco. Duress. It's interesting, Sarah, that you should mention that because there is an undue influence case that is a little bit like this.
I completely, once I read 1 or 2 cases on duress, I was done.
Yeah, there is a case called Louth and Diprose. It's an undue influence case, and it bears some similarity to what goes on here. But of course, here we need to assess things, just in terms of misrepresentation.
Yeah.
So, let's yell out the issue then. Oh, sorry, she spent the money. He thinks that on the money on other stuff was TV, laptop, car, pay TV connection, etc., etc. He thinks that it was all a lie and she never needed the money for the drug fiends. What does he want?
Money back.
His money back.
Yes. There's one about the elderly folks in a bank. Yes, that's Commonwealth Bank in Amadio, Tim. We'll get to that in unconscionable conduct. So you can see, everyone's kind of picking up on this. She couldn't be dealing with Telstra, she'd still be waiting. You can see that there's an undertone in all of these vitiating factors, isn't there? You can see almost that there's a common smell underneath them all, isn't there? There's some naughtiness going on. And if you're going to be successful in an action for misrepresentation, I guess if maybe not in terms of innocent, they've still done the wrong thing, although they haven't meant to. Negligent, they just didn't care about it. Fraudulent, they've actually intended to deceive the other party. But in terms of duress, there's a threat, again, naughtiness, in terms of undue influence. Usually there is a power asymmetry between the parties. There's a relationship that would suggest dominance and weakness, and one party has taken advantage of that. With unconscionable conduct, you have the whole issue of, is one of the parties under some kind of special disability? Okay? In all of these things, you can see why the law has devised a means for parties to get out of what is essentially an unfair situation. Okay? There are reasons why their consent to this particular contract should be vitiated. They are vitiating factors. Okay, so the issue here, obviously, for us, given that we're looking at misrepresentation, is can Rocco obtain, have the contract set aside for this? This is a view from Rocco's side. Yes, because he's the one that's come to the solicitor and asked for advice. And get his money back. Okay? Rules, people. Hit me with them. Is there a case rescission? Yes. Nice technical word. That's an HD word, Sarah.
I've been studying all day.
Nice work. And I guess to put this in more technical terms here, and we'll put here and recover his money paid over to Maria. That's a nicer way of saying it all. Okay, so, we'll save a number of that. Okay, rules. There are some cases that should be section 18. Oh, is that what you've been looking at all day, Sarah? Or is that the way that you analysed this? Did you look at it in terms of fraudulent misrep?
Yeah.
Good.
Yes.
Good. Okay, so looking at the rules here, what would you say? What are the elements? What are the, what do we need to show?
Party makes a statement that they know is to be untrue.
After existing fact. Yeah. Intent to deceive. False statement of past or present fact. Yep, that's it. And the next one?
Party knowingly makes a partial statement, which has the effect of conveying a falsehood.
Yes, we'll get that's all part of one.
Yeah.
Addressed to the other party, at or before, when?
Time of the contract.
That's it. And thank you, Tyler. Intended to and did induce the contract. That's it. Okay. So for fraudulent misrepresentation, what else do you need to show? It's here. It goes to element number 1. The statement must be made. Tyler, knowingly made. Yes, intent. You're picking up what I'm putting down. So I'm just going to copy and paste here. All right. Now, statements are made knowingly or without belief in its truth, or recklessly careless of whether it's true or false. The intent should be acted on by someone induced to contract. For fraud, you need to show subjective intent. Subjective intent. So is that going to be an easy thing to show or a hard thing to show? How high is this bar?
Very high.
Yes. Unless you've got a smoking gun, it's really, really hard to show fraudulent misrepresentation. So therefore, as the smart practitioners you are, would you then possibly, and this is just throwing it out there for you, at that point you might say to yourself, I will go and have a look at the state legislation to see whether I might be more successful under the statutory version of the Competition and Consumer Act in my state. Why would you be saying that to yourself? What's the big difference between the statutory form of misrepresentation and the common law of misrepresentation? Do we have these categories? Innocent, negligent, fraudulent? Do we have those under statute? Ha ha! Thank you, Tyler. That's it. Statutory does not require intent. So that would be one big reason why, if you are having trouble here, you may well decide, after you've gone through this analysis in terms of the common law, you may well recommend to your client that they have a look at the statutory form of all of this, which is misleading or deceptive conduct. Okay. So I am thinking here of a particular case. What was the case that held that set out these various different elements for fraudulent misrepresentation? An old case.
Is it Peak and Dairy?
Dairy and Peak. Mm-hmm.
Dairy and Peak, sorry.
Mm-hmm. Dairy and Peak. Yep. What happened in Dairy and Peak? Does anyone know? In Dairy and Peak, I'll do another copy and paste for you. Obviously, you wouldn't be putting this into your IRAC. So that was the case where the company issued a prospectus saying the company was entitled to use steam or mechanical power rather than horses. The Board of Trade refused consent except on conditions. The company was wound up and Peak sued for damages for fraudulent misrepresentation. The defendants said that they thought they would get consents from the Board of Trade. So they were therefore not liable for deceit because at the time the directors made the statements, they believed that they were true. So this is what you're pushing up against if you're trying to make an argument of fraudulent misrepresentation, right? Quite a high bar there to try and have to jump over. Partially true statement. Yes, okay, Sarah, what would you like to say about that? It goes to this element here, doesn't it? Half-truths, is that what you're thinking of? Sarah? Yeah. You mentioned partially true statements. So are you thinking of half-truths? That's in relation to silence. I think that's what you were having a look at today in your research, Sarah. So she actually has said to him, if they mislead, here we have the issue of silence and half-truths. What is the test for belief that a thing is true? Well, Keith, unless you can show, the onus of proof is on the person alleging the fraud. So unless you can show that they actually had no belief in the statements that they made, you're not going to get across the line. Very high bar here. You have to show, if you want to get out of this contract and say, yes, it was a vitiating factor here, the vitiating factor was fraudulent misrepresentation, you have to show that the representation was made knowingly. The false representation was made knowingly. That is, you have to be able to show that they told a lie, right? Or B is a bit more like negligence without any actual belief in its truth. It'll still be fraud, but it's a slightly different form of fraud, isn't it? It's like gross negligence. They had to show they relied on the statements. Yes.
That's very fine.
Well, it's very difficult to show. And it's one of the very, very few times in contract law that you will ever have to make an inquiry about a person's subjective state of mind, isn't it? All through contract aid, what did they say to you? Everything's all about objectivity, isn't it? Always. Why do you think they have to go from subjective intent here? Why do you think we are pushed into a measurement of subjectivity? What's at stake? What are you going to get convicted of?
Well, there's damages and fraud, probably.
Yes. So effectively, the court is branding you a fraud, and you may well have to lose the benefit of any contract and pay damages. This is extraordinarily serious behaviour. And a court is not going to call someone a fraud unless there is very, very clear evidence. Okay? So extraordinarily difficult. And that's why I said, you know, once you go down this path of analysis, you may well find that you run to the arms of the Competition and Consumer Act. Because there is none of this argy-bargy about intent. Okay? Okay, so Edgington and Fitzmaurice said the state of a man's mind is as much of a fact as the state of his digestion. So, in that case, what happened? What happened in Edgington and Fitzmaurice? It's a bit of a bookend case to Derry and Peake. We had in that case, someone's saying to me something in the chat. Hold on. Issue of debentures. Thank you, Tim. Yes, it was. I'll just do another copy and paste. Here we go. All right. The company issued debentures for alterations to buildings, purchases of horses and vans. The money was actually used to pay company debt. And in that case, it could be shown that they never had the intent to use the money for those reasons. They wanted to pay down company debt. Okay? In those circumstances, fraud. Okay? So if we go back to our IRAC, what would we be saying? First element, false statement of past or existing fact. What has she said to him? She's got to pay off drug lords. What do we know? What do we know? What's Rocco told us? Similar to Maria, if it can be proved she had no intent on using the loan to pay off a debt to alleviate personal harm, Edgington and Fitzmaurice. In fact, she used the money for purchase of luxury items. Yes. So, Nicole, can you expand on that? And do we know, can he prove she had no intent when she was making this contract with him that he initially resisted and they ended up writing out some terms? Can we show that at the time they entered those terms, she had no intent of using that money? Unless we have Maria told her workmate she bought a car. Yes. Does that mean that she also did not use the $30,000 she was given by Rocco to pay off a drug lord? She broke up with him after she got the money. Well, you know what? I think I probably would too, because he kept saying that he made advances to her and she didn't return any feeling back his way. I mean, she probably didn't particularly like the man. I don't think what I'm trying to say, Sarah, in terms of that is, when you are looking around for facts to support an argument, you must show a direct and logical line from one proposition to the other. Just because she broke up with him does not mean when he started questioning her about the use of that money, you can't draw an inference of guilt from her ending a relationship. Okay. And whatever happened at the point in time when he was questioning her uncomfortably about her use of the money, that whatever occurred at that point in time does not necessarily draw you a direct evidentiary line to her mental state of mind when she was actually concluding the contract. Okay? Get the feeling she used him. Yes, of course you do, but you can't litigate based on feelings.
No, yes. Wrong word.
So what can you show? What can we show? Is it more like the Derry and Pete case, or is it more like Edgerton and Fitzmaurice? Do we have a smoking gun? Yep. I think he has nothing. I think so too. No smoking gun. The only thing that, in these situations, if they had, for example, if they had a relationship for a while and they had mutual friends, for example, that Rocco could ask, look, did she send you any texts at the time I lent her money? Did she say anything to you about asking that she was going to ask me for money? That's the way you'd go about gathering evidence, the kind of evidence that you would need in this kind of action. Yeah, so Rocco could have made the whole story up. Yes, essentially. Of course, he could have. He might have got ticked off that she wasn't returning his advances. He might have got ticked off that she dumped him, and he's just trying to back out of the whole deal and make it uncomfortable for her. She could argue he gave her the money out of good faith, but because she didn't really like him, she asked him to sign the contract. Possibly.
Presumptions. You can't go off that.
He gave her the money out of good faith, but because she didn't really like him, so she's saying it's a matter of trust. Nicole's saying it's a matter of trust here. Again, what I guess I'm trying to marshal you back to is, what can we show? Where are the elements? The first element, false statement of fact. We can't even get past that because we can't prove that it was false, can we? What I'm saying is, would it be he said, she said? Essentially, yes. And you're not going to find someone guilty of fraud just based on a he said, she said. It's too serious. A court won't do it. We don't even have the napkin. I know, right? Yes, I have the same question. What was the contract exactly? Well, the contract was, we don't know because the terms aren't given to you, but we would assume that they are, I will give you $30,000 and you will pay me back. I mean, I think that the sensible thing here would be for Rocco, instead of trying to get out of it with an action for deceit, the far more sensible thing would be, what? If there are contractual terms here, what would you try and do? Yeah, if she's not paying, yes, thank you. Now you are thinking like lawyers. Woo, woo, woo. If you've got a contract, don't wriggle out of it. If you've got something in black and white, something was agreed. If there were terms and conditions, I'll give you $30,000. You will pay me back, $10,000 a year for the next 3 years, or $5,000 a year for the next 6 years, or however it was there. You're going to be arguing, come on now, pay out. If there really is a contract. Well, exactly. We don't know what's in the contract. Yes, that's true. The other thing is, how much does it cost to sue someone? How much money is at stake here? About 150 grand to sue someone. Yeah, 30 grand. So unless she can go to QCAT and kind of, act for herself, you would find that $30,000 would be gone in legal fees before you know it. Barristers cost $6,000 a day, and that's a junior. That's what I'm paying my junior. So only 10K to give concrete boots. I love it, Tim. So I think we've basically fallen over. The question said to ignore formation. Yeah, what we are looking at here is we are looking at would Rocco succeed in getting out of the contract in terms of misrepresentation. And that would mean, so to join all the dots together, if he can get out of the contract for misrepresentation, then what does the court do? If the court sets aside the contract, what does he get back? Money. Yes. Yes, he gets his money back. So if a court rescinds the contract, they will unpick it. Okay, the contract's voidable. If it's rescinded and they take up that opportunity to set aside the contract, it's as though the contract never started. And the court will put the parties back into their starting positions, which means she will have to hand that money back. Okay? So that's why we are looking at misrepresentation, in case you got a bit confused there. Okay? Otherwise, what I'm saying is if you're going to have too hard a time trying to prove misrepresentation, you may want to say, well, hang it, I will sue on the contract and maybe get my money back that way. And if the contract gets set aside, he still has the issue of trying to get the money back when she's already spent it. That is the other issue. But I mean, that's the same issue whether he sued on the contract as well. It's the issue of enforcing judgment, isn't it? And that's where you always run into, and this is why you need to look carefully at the issue of whether or not your client's going to be able to get the money back at the end of the day. Because I tell you what, you have a client that's pretty unhappy if there was only 30 grand wastage to start with, and then they spent 150 grand on trial to get an order for her to pay him back 30 grand, and she was bankrupt. Warrant and seizure of assets. Well, I don't think a second-hand car, a second-hand laptop, and a second-hand TV is going to get a whole lot of money. Okay, Sharon, I understand if you need to go. Did we kind of get our heads around that? Was there, so we've got only as far as the first, and I think she's already fallen down on that. We know it was addressed to the other party. We know it was added before the time the contract was made. We know it was intended and did induce the contract. And we know that they did enter the contract. They fall down on number one. So all of your battle would be, and all of your most of your legal advice would be devoted to element one. Okay? I don't like Maria anymore. Any queries or questions? I'll stop sharing. Queries or questions? So you can see why knowledge of the case law is super important, right? The way your IRAC would run would be, well, we need to prove a false statement of fact. If we're going to try and prove deceit, then we need to show that these three things from Derry and Pete, knowingly or without belief in its truth, or, you know, careless whether it be true or false. Now, you'd set all that out and you'd say, this is what we have to show. On the one hand, in Derry and Peak, they couldn't show that at the time the statement was made that they weren't going to use that money for those purposes. But on the other hand, in Eddington Fitzmaurice, because they did have the actual proof that the company was trying to pay down debt, they could show that when they said they were going to use the money for purchasing horses and vans and that stuff, it was untrue. Here, then you'd bring it back to your facts. Like I say in my IRAC tip sheet, bring it back to your facts. Here, is our fact scenario more like Edgerton and Fitzmaurice, or is it more like Derry and Peak? Well, these are the things that we can show. We know that she's all of a sudden come up with all of these goodies, but do we know that at the time she made the statement, she had no intent to spend the money in the way that she represented? Yes? That was a lot of energy. Yeah. All right. See, I told you, you don't need to go to the gym with contract law. You expend all your calories in thinking. Open mics. Any queries before we have to shoot off? Okay, folks. If you do think of any questions afterwards, just shoot me an email or post up something on the Moodle forum or post up something on Facebook. I look forward to receiving your IRACs. I've had some great IRACs this week. Oh, my word. I've started playing around with voice memos to give you your feedback. So I hope you enjoy those. And if you need me, you know where I am. Go and enjoy a nice dinner and a cup of tea. Scratch my head for a while. Would you recommend attending the tute if you haven't done the reading? You will certainly get more if you have done the reading. And I would heartily recommend you doing the reading before the tute, yes. No worries, peeps. You know that you've always got the recordings here anyway if you need to come back to them. Okay. Go and do something kind to yourself. Bye, guys.